Rely on your common sense. Don't speculate. Don't get sucked down that rabbit hole of hypotheticals and misdirection. What ifs and could haves are not the law, and none of that changes what actually happened here. What the lawyers say is not evidence. And you have an instruction on that. Even if we bang on the table and yell and stomp our feet, still not evidence. And anything we say doesn't change what actually happened in this case. Your job is to look at the evidence, to use your common sense, and apply the law. And how are you going to do that? You can do that any way you like. You're the jury. But the videos are an important part. You can go back to the videos. You can play them. You can rewind them. You can pause them. There are several videos you can review. And you'll have them on a laptop with all the other exhibits in this case. You'll also have the gun and the taser back there when you deliberate. They will be made safe for you, of course. The ammunition will be separate from the gun, but you'll be able to hold the taser and hold that firearm to compare those features, to get a feel for the two, and to get a sense of all those differences that you heard about in court, and see for yourselves how different they really are. And you'll also have those exhibits that are the training materials and the policies. And why are those policies important? Well, of course, a violation of policy in, of, and by itself is not a violation of law. You have an instruction on that. But the policies are important because they show what the standard of practice is, what the officers are expected to do as part of their jobs, what they're expected to know, what they're expected to do and not do. They include the things to consider in deciding to use force and how much force to use. And importantly, they show that the police industry as a whole has been aware of and has taken all kinds of steps to address and prevent things like weapons confusion for decades. There are a lot of policies. You'll have a lot of documents. There's also one that includes language about spark testing. Why is the spark test important for a taser? Members of the jury, spark tests are important because they rebut any claim by the defendant that she spends more time using her gun than her taser. The point of a spark test is not only to check to see that it's working, to make sure your taser is functional, but it's also to put your hands on it. It means you have to pull it out, hold it in your hand, put your finger on the trigger, and test fire it every day you work, before every shift. That's the expectation. That means that every Brooklyn Center police officer should have their hands on that taser every day on the job. Every day she was supposed to practice using that taser. Now, the defense may refer to this as an unfortunate mistake or a tragic accident, or that because the defendant didn't know or didn't realize that she had a gun in her hand, that this is somehow an accident and not a crime. That is simply not the case. It's just plain wrong. Accidents can still be crimes if they occur as the result of recklessness or culpable negligence. You're not going to find the word accident or mistake or error anywhere in your jury instructions, because it's not a defense to the crimes charged. An accidental killing is still a crime if the defendant's actions are reckless or culpably negligent. And the defendant's failure to recognize she was drawing and handling and firing her gun, despite hours and hours of training, despite years and years of experience, despite the clear differences between the two, and despite the opportunity to change course and correct, and despite all the warnings and cautions against doing this very thing, is part of what establishes the defendant's recklessness and culpable negligence in killing Daunte Wright. On the subject of errors or mistakes, you heard from Dr. Miller that action errors that we sometimes see are those things like misdating a check or entering the wrong password. And as I said, members of the jury, drawing and firing the wrong weapon is not the same as misdating a check. And doing something for 26 years does not automatically override another thing you've done for 19 years. There was a lot of discussion from Dr. Miller about the medical field, the field of aviation, and how errors can happen. But anyone can be prosecuted for their criminal negligence. Anyone can be prosecuted for reckless driving or child endangerment. And anyone can be prosecuted for reckless handling of a firearm. The same applies to police officers, just like anyone else. But people who do the job right should not be judged by those who do it wrong. And this case is about only one person's conduct. It's about the defendant's actions in killing Daunte Wright. It's about her recklessness. It's about her culpable negligence. The professional world is based on the principle that instruction and training and practice and prevention, that those things work. And that people have to be responsible for following their training and being aware of risks. That's what training's for. You can rely on your common sense. Training works. Human nature did not kill Daunte Wright. The defendant did. The defendant told Dr. Miller, "I don't make mistakes. Take that for what you will." She also told him that the car was running. The car was on. So she knew she was firing on the driver of a vehicle, which makes any decision to use the taser even more dangerous and more risky. She also told Dr. Miller that Officer Lucky and Sergeant Johnson backed away. They disengaged when she said taser, taser, taser. So apparently, that's all it took to call them off. And once they backed away, there would have been zero risk of anyone being dragged. There would have been no need to fire any weapon at all, no matter what she may or may not have initially perceived. In this case, and in her career, the defendant consciously and intentionally took on a very important and very serious responsibility. She chose to become a police officer. And she failed in that responsibility. She betrayed her badge, and she betrayed her oath. She betrayed Daunte Wright and her fellow officers, too. And her conduct was criminal. This case is not about Daunte Wright. Daunte Wright is not on trial. He's not the reason we're here today. So whether or not you agree with his decision to flee is not what this case is about. He's not the defendant here. This case is about Kimberly Potter. We're here today because of her conduct, her choices, and her actions. We're here today because she killed Daunte Wright. But this case is also not about the defendant's law-abiding or peaceful nature that you heard about. It's about what she did on that day, on April 11th. It's about her rash and reckless conduct. You heard from a number of people that she's a good person or a good cop. You heard from a lot of people in her police family. Members of the jury, good people can commit crimes. Police officers can commit crimes too. And it should come as no surprise that the defendant had a reputation for being law-abiding before April 11th. She was a police officer, and that is the expectation. And just because she didn't kill people for the first 25 years of her career does not mean that no crime occurred on April 11th. This case is also not about whether the defendant is sorry or whether she's remorseful. Of course she's sorry. Of course she feels bad for what she did. There's no dispute about that. But that has no place in your deliberations. Your duty, members of the jury, is to decide this case without sympathy. And you have an instruction on that. And without considering in any way any possible penalty or punishment. You've got an instruction on that too. Be fair, act honestly, deliberate without prejudice, bias, or sympathy, and without regard to your personal likes or dislikes. This case is not about remorse. It's about the defendant's actions in shooting and killing Daunte Wright. And you were all selected for this jury because you said you would follow the court's instructions and apply the law. That's your only job in this case. That's what you're here to do. In this case, the defendant made choices, a number of choices, and those choices killed Daunte Wright. She chose to engage, she chose to use force, she chose to escalate, she chose to draw the weapon on the right side of her duty belt, she chose to reach her right hand down to her holster, she chose to ignore the feel of that holster, she chose to ignore the weapon in her hand and how it came out of the holster, she chose to put her finger on the trigger, she chose to ignore the feel of the trigger. She chose to ignore the feel of the grip. She chose to ignore the weight. She chose to ignore the color. She chose to ignore that there was no display and no lasers and no flashlight of this gun that was in her right hand, right in front of her face, with her right index finger on the trigger, aimed directly at Daunte Wright. She chose to pull the trigger. She chose to fire. She chose to disregard her training and to disregard the cautions and the warnings and the risks. She knew she had both weapons on her duty belt. She knew how to get it right. But she failed to get it right. She failed Daunte Wright. The defendant alone is responsible for her choices and her actions. Daunte Wright did not cause his own death. We're here because this was entirely preventable. It didn't have to happen. It was a tragedy of her own making that it's not just a tragedy. It's manslaughter. That she was an officer does not make it okay. That she was on duty does not make it okay. That she shot him with her service pistol does not make it okay. Her actions were rash and reckless, and what she did was wrong. We trust the police to safeguard lives. We trust them to do that until they don't. The defendant shattered that trust when she shattered Daunte Wright's heart. She chose right instead of left. She chose wrong instead of right. She chose her gun, and she shot and killed Daunte Wright. Thank you.